So we got a guy here with a fez and the last name Bay, so you just know that that's going to be juicy. Now, I've heard a lot of gibberish in court before, but this is about as good as gibberish gets in these scenarios. How this guy thinks that he's going to get away with any of these really serious charges just because he claims I don't actually know what he's claiming. It's absolutely beyond me. Let me get a good old nickname for this fella.
All right, so Mr. Hensley, I think I see where we're at now. So it looks like court denied a motion to stay proceedings on January 23rd, and then there was an order from the Court of Appeals on January 26th. So 3 days later, it looks like that your claim of appeal was dismissed. And then you filed on February 9th a notice of appeal to the Supreme Court. I'm trying to find the exact verbiage here of your motion. The motion to stay execution pending appeal of the bond to be waived. Okay, so we can hear that quick then, sir. I do have to go through these series of questions. You probably know them by now as well as I do, but I still have to ask them all. We'll have to go through all of that, sir. So if you raise your right hand, I'll have you sworn, Mr. Hensley Bay. Sir, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I affirm.
All right, you can put your hand down. All right, Mr. Hensley Bay, as I've noted, we've gone through this several times. I just need to find our list here. But you are appearing here today representing yourself. And is that what you'd like to do today, is to continue to represent yourself on the motion that you have filed asking for a stay of the proceedings?
Yes, I do present myself, yes.
All right, but you wish to continue to represent yourself, is that accurate?
Yes, I continue to present myself, yes.
All right, and then Mr. Hensley Bay, do you understand that representing yourself can cause you to be at a disadvantage, particularly as it relates to the people who are represented by attorneys, and recognizing that you could be at a disadvantage, you continue to wish to represent yourself? Is that accurate?
Correct.
Okay. And Mr. Hensley Bay, as I mentioned before, that if you wanted to, you could ask for an adjournment. I'd actually grant you that adjournment. If you wanted to hire an attorney, are you waiving your right to go hire an attorney then?
If I need outside counsel, I can get it. Gratitude.
Okay, but you're not requesting an adjournment to go hire an attorney and have them represent you on this motion, are you?
No, I'm not.
All right. And you also understand that if you were eligible, you could petition the court for an attorney at no expense to yourself. Are you waiving the right to request court-appointed counsel?
At this time, yes.
All right. And this, Mr. Hensley Bay, do you understand that if you go forward representing yourself again this morning, as you have in the past, that the court is going to be required to treat you the same as I would any other person appearing before the court, whether attorney or not? Do you understand that?
I do not, but
Well, when you say you do not, we've had that argument before in a motion, right? So you're referring to the idea that you thought that there was a case out there that would suggest the court has to give you a lot of deference or wide latitude because you're representing yourself. Is that accurate?
Yeah. Kearney versus Hain. Yes, ma'am. Yes.
All right. And then we have debated that in the past. The court has denied that, saying that I don't believe the case stands for that proposition. And then if you go forward today, again, I'm going to have to treat you the same as I will Mr. Butler or any other representative from the people. Do you understand that?
I comprehend, yes.
Okay. And then Mr. Hensley Bay, again, I'll remind you that the charges that you're facing are serious. Those are 5 years of incarceration. That's a maximum penalty on the carrying a concealed weapon charge. Up to 4 years of incarceration on the assault, felonious assault charge. And then the big one here, this felony firearms is a charge that carries a maximum penalty of 2 years consecutive with and preceding any term of imprisonment. So again, explaining that you'll have to serve 2 years, no discretion by the court or anybody else. It has to be 2 years before you begin serving any sentence that would be associated with 1 and 2. Do you understand that those are serious penalties and that there are risks by you continuing to represent yourself? Do you understand that?
I comprehend. So the time went up on the charges, or because last I was heard it was 2 years, 2 years. So now one is 5 years.
Count 1 is 5 years. Count 2 is 4 years, and count 3 is the 2 years consecutive to 1 and 2.
I heard nobody.
Same penalty that I've read to you over and over and over.
Yeah, I don't remember the numbers being that large, but okay.
All right, but I have to give them to you again today, like we have, and you still wish to go forward on your own? Is that accurate?
I still present myself.
Very good. Do you understand that as it relates to rules of evidence, court rules, that if you continue to represent yourself, the court will have to hold you to those rules, just as I would any other attorney appearing in the courtroom?
So is that the same as you talking about my constitutional rights when you say the court rules?
Yeah, you certainly have constitutional rights, but as it relates to the court rules, the court will have to hold you to those like I would anybody else, including attorneys. So in other words, I can't give you some wiggle room on deadlines or something like that that might be found in the court rule. I have to hold you to the same rules. Do you understand that?
Mm.
You understand that, Mr. Hudson Bay?
Can you repeat that one more time for me, please?
Sure. I'm going to get Mr. Franklin in a breakout room here while I'm doing that. Right. There we go. I think we got it squared away. All right, so Mr. Hudson Bay, back to the question at hand. Do you understand if you go forward today representing yourself that I have to hold you to the same standard as it relates to court rules or rules of evidence or anything else as I do attorneys? Do you understand that?
I comprehend.
Okay. And knowing that you still wish to go forward on your motion today representing yourself? Do you want to go forward representing yourself today, recognizing the court has to hold you to the same rules?
Yes.
Okay, very good. All right. All right, Mr. Butler, do you believe the court's complied with 6.005?
I do, thank you.
Okay. I do find that again this morning, Mr. Hensley Bay's waiver of his right to counsel and his request to continue to represent himself has been done knowingly, intelligently, and voluntarily. It's unequivocal. And I think the court also can rely on the prior times Mr. Hensley Bay has been in this courtroom. It's been numerous. His answers have always remained the same with his desire to represent himself. He's always acknowledged that if he did need counsel, he would retain counsel, or that he would exercise his right to request court-appointed counsel. The court's also satisfied that it has, again this morning, explained the dangers of self-representation to Mr. Hensley Bay and that he'd be held to the same standards as other members of the bar or other individuals appearing before the court. So I'll allow him to continue with his self-representation. And then Mr. Hensley Bay, you're welcome then, sir, at this time, then to give the court any argument you'd like on your motion here that appears to be a request to hold the proceedings in abeyance, a stay, pending your request for the Supreme Court to look at this matter. What would you like to state in support of your motion, sir?
Excuse me, pain. I'm coming. Yeah, I'm coming. I'm just gonna read my motion. Defense motion for stay of execution pending appeal and bond to be waived. Come now, Milton Hensley Bay, in aforementioned case, with a motion to stay. Defendant move for an order staying execution of or any proceedings to enforce the final dispositions judgment entered in favor of Ione County Prosecutor Kyle Brandon Butler on January 8, 2024, pending disposition of defendant's appeal, which was filed with the Michigan Supreme Court on February 8, 2024. Defendant further moves that as defendant is indigent, no superseded bonds be required by the court, or if one is required, that no sureties be demanded. This motion is based on MCLA 600.2605 on MCR 3.604L. In support thereof, I am writing to request a stay of proceedings pending appeal in the above mentioned case. The purpose of this motion is to prevent irreparable injuries to the defendant appellant if the request stay is denied without causing harm to the appellee or the public interest if the stay is granted. Nature of irreparable harm. The denial of due process during the trial proceeding has resulted in specific irreparable injuries to the defendant appellant. The right to a fair and impartial trial is a fundamental aspect of due process under the Constitution. The denial of a continuance and the subsequent trial proceeding, which precluded critical evidence, have impeded the defendant appellant ability to present a robust defense. Denial of continuance. The defendant appellant motion for a continuance pending discovery was denied. Limiting the time available for adequate trial preparation, this denial directly infringed upon the defendant appellant rights to present a meaningful defense. Trial preclusion of evidence. During the trial, the court's ruling led to the exclusion of critical evidence sought by defendant appellant. This adversely affected the defendant's ability to mount an effective defense and deprive the defendant of a fair and impartial trial. Potential for sentencing before mandate. A particular concern is the risk that the trial judge may issue a sentence before the appellate court can issue a mandate. Such premature sentence would cause irreversible harm to defendant's appellee, as the appeal process may subsequently reveal errors or injustice in the trial proceedings. Lack of harm to appellee and public interest. Absence of harm to appellee. Granting the request stay will not cause harm to the appellee. The plaintiff appellee's interest can be protected without jeopardizing the defendant's appellant rights to a fair appeal. Public interest court consideration. Upholding due process rights is the public interest. Ensuring a fair and impartial appeal service and broaden goals of justice. And indigence of defendant. The defendant appellant is indigent and therefore should not be required to post supersede bonds. Conclusion. I formally request that the court grant a stay of proceeding pending appeal and, if necessary, waive the requirements for a superseded bond, or in the alternative, allow the defendant appellant to proceed with surety duty to indigenous. See attached proof for appellate court filing in attached exhibit. Closing. Express appreciation for the court's consideration of the motion and provide contact information for any further communication. Supreme Court case number is pending. I also reserve my right to amend this motion and more grounds to be argued or attendance. Thank you, Your Honor.
Okay, Mr. Butler, what's the people's position here?
Thank you, Your Honor. This motion is very similar, not identical to what he had previously filed, so our response will be the same. The only difference is that we have received an order from the Court of Appeals, and that was dated January 26th, in which the Court of Appeals dismissed the defendant's claim for appeal. So then the defendant did file then with the Michigan Supreme Court, and that same day that he filed, the court rejected his filings. So there isn't anything that's currently filed, appropriately filed, in either the Court of Appeals or the Michigan Supreme Court at this time that I'm aware of. So we would ask that you then deny the defense now second motion for stay.
All right. So it is accurate that the motion before the court today is similar to the one that the court denied back in January 23rd of 04. At that time, there was a motions filed in the Court of Appeals. It was the court's belief that they were premature at that time. And then a January 26th order from the Court of Appeals dismissing those orders or that request for review as not being right in essence. And then Mr. Hensley Bay has filed something with the Michigan Supreme Court. I don't know what the status of that is. The prosecutor it's been. Hold on, sir. Let me finish, and then I'll let you say what you want. And prosecutor suggested that those filings were not accepted. I don't see anything in the file whether they have or haven't, and it does not impact the court's decision regardless of what's going on here today. But if I could, in a thumbnail, identify the appeal that the request for stay that Mr. Hensley Bay filed earlier, this one today, are his attempt to have appellate review of different trial court decisions that were made during trial. And that review, again, I don't think is appropriate for any appellate court until there's a final judgment, meaning sentencing. We haven't got that far yet because of these motions. So again, I don't believe that there is any legal justification, a court rule that would suggest that the court is required to grant a stay. Court is not going to grant a stay for all the reasons I've stated on the record here, and that in essence, what Mr. Hensley Bay is attempting to have reviewed is something that can only occur after we have a final judgment, which is sentencing. And then the entire record of the trial, and motions and anything that occurred prior to that date can be reviewed then. And he'd have an appeal of right, as I've mentioned in the past, because of the verdict after trial. So it wouldn't even be the lesser request of a claim of appeal. I'm sorry, seeking leave to appeal. He'll have a right to review of the trial and all decisions that went into it. So respectfully, Mr. Hensley Bay, I'm going to deny the request for a stay here today. Mr. Butler, I'd ask that your office prepare an order indicating the same, and let's make sure so that it's easy to track, or as best we can, that the language that Mr. Hensley Bay has used is in that order. It's denying his defense motion for stay of execution pending appeal, bond to be waived. All right, that was filed on February 9th. And then Mr. Hensley Bay has promised, so I'm denying the stay, but do you have a question?
Yeah, I mean, the only reason why the appellate court, one of the reasons why they denied the motion, because I don't have the transcripts yet, and I don't have any information saying that the Michigan Supreme Court denied anything, because they. Well,
that's what I said. I don't have anything either. But so here's the thing: I'm denying the request today. Now, the Supreme Court, if they sign an order that says, "Wait, we're granting your request for a stay," then this court has to follow any orders that would come from the appellate courts. I don't have anything in the file that would suggest that.
Okay, but you do have my paperwork that I did file with the Supreme Court, and you have the numbers on everything The date that
Well,
I filed.
I have what you have titled Notice of Appeal to the Supreme Court of Michigan, and
Okay.
the case title is TBD, I assume to be determined.
Yes.
So that is in the file. It was received on February 9th.
Yeah. I can't do nothing until I get those transcripts, though.
Okay. So next order of business then is Ms. Bond is here. We had a pre-sentence report completed.
No, not yet. He's scheduled for sentencing on March.
Okay. Does he have a date that he's to report to?
I was gonna actually make contact with him this afternoon.
All right. So Mr. Hensley Bay, absent some direction from the appellate courts, it sounds like probation will be contacting you to begin the process of completing the pre-sentence report. And what was our sentencing date?
March 5th.
So March 5th looks like will be our sentencing date. Okay. So make sure you respond to them and get that completed, because I don't want you to be violating the terms of your bond or something of that nature. And I'm not suggesting that you would, because you always appear and you're always polite and respectful. But they're going to be reaching out to you to get that scheduled and get a sentencing date. Okay, sir?
Okay.
Okay, you are free to sign off. Thank you, Mr. Hensley Bay.
All right. I come today and get that order that denial.
I didn't catch that last part. What was that?
That order that he denied, you denied. Can I pick that up?
Mr. Butler's going to prepare that order. I assume that can be done today. I'll sign it, and then it'll be filed at the clerk's office. And you are certainly welcome then to contact the clerk's office for a copy, so that you have it for your records.
Okay. Gratitude.
Okay, sir. You're all set today. Thank you.
All right.
I got nothing. I don't know how to even respond to this kind of thing. Again, how he thought he was going to get away with it just because he starts using some fancy words that he pretty much can't pronounce is absolutely a mystery to me. But let me know what you think down below, folks, and we'll catch you in the next one. Sláinte. Now, one of the best things about being a sovereign citizen is the fact that you don't have to follow any of the rules. Or, well, so they think. And this guy's expressing his sovereign right to not pay rent. He states on his Facebook page that he is the North Moor. So you can kind of see where this is going already. For those of you who don't know, a Moor is a type of sovereign citizen. So when they tell him that he's got to get booted out, he comes up with some very interesting reasons why they simply cannot boot him out.
Miss Black, Jean, do you live in the same residence, or are you just here as an interested party?
I'm here as an interested party who would just like to, at some point, enter information into the record.
All right, well, we'll see where we get that far. Miss Foster, this is correct. You want him to move out?
Yes,
All right.
it is a month-to-month lease, so we do not want to renew his lease.
All right. Mr. Black, what's your position?
I would like to know, first off, why. Second off, why Miss Lolita, if she is the actual landlord, why she has not spoken with me. Why, whenever there is an issue, I have to speak with Mrs. McNary. Every issue that has ever came up has been dealt with. I thought to the approval of said person I'm supposed to speak with over this property. I'm funded by Keystone. I've even actually paid cash on top of my Keystone funding. And I would just like to know, what did I do to want to be removed?
Well, first and foremost, the landlord doesn't have to talk to you if they don't want to. It seems in this case that the landlord has an agent or a manager that's looking after it. That's absolutely their right. So that's not going to get you out of this. Number two, just because you're getting Keystone money doesn't mean that they have to continue to rent to you. That's completely aside from any agreement that you've got with the management or with the landlord directly. So that's also not going to help you. Let's see if you can come up with something, bud.
I guess she doesn't have to answer that question.
Okay.
If she wants her property back on a month-to-month lease.
Okay, now which lease
All right,
is she using as this one?
Well, the one that's
lease?
here.
Now, I got dogs abuse the other day for using the word smug apparently wrongly. Can you all at least agree that this guy's smug, or is about to become smug? Let me ask you this, Judge. Exactly which lease is she using?
Yes, the one that's
Yes,
not
a
my signature and the
month-to-month
second
lease.
lease.
Started February 1st of 2022. February 1 of 22.
I thought I was out of the shelter right after Christmas. I didn't think I was waiting until February to move. I thought I moved here in January.
Well, that's the date on the lease I'm looking at.
Yeah, well, where's the actual original lease that Keystone has?
I don't know the answer to that. Maybe Keystone has it. Well, anyway, the law says I have to adjourn this for 7 days. So to look into some of these questions, but ultimately, Mr. Black, if a landlord wants to terminate a tenancy on a month-to-month tenancy, they serve the notice to quit. And they
What's that?
can, let's say the reason is she wants to rent it to her nephew.
Okay,
Or she wants to tear it down and put up a parking lot.
correct.
Or she thinks you play your music too loud, or she
Yeah.
wants to move into it herself. She doesn't have
She
to
doesn't
give
have
you
to-
a
she
reason.
doesn't have to have
She
any
just has
reason.
to go
Okay.
through the steps.
Okay. Can I ask a question? Does that notice to quit have to be filed?
Yeah, it was filed.
Oh, it was?
Yeah.
Sure.
Yeah, let's take a look.
Mm.
It was filed on June 7th. She asked you on May 7th to move, and now we're in July.
Okay, so
Um,
June. Wait. Say that one more time, please.
She
It was
served
filed
the
when?
notice to quit on
She
you
served.
on May 7th,
Sir, but when was the notice quit filed?
June 7th.
Okay. Huh? Hmm.
What, you got something to say? Say it, goddammit.
Yeah, and
All right,
also
I'm
when
gonna
that
continue this.
got the
to
letter where
next-
my funding was supposed to be canceled as well, and I
Well, I don't know, Keystone was running out
Yeah.
of money, I do know that.
no, they
How
didn't run
about
out of funding.
August
I got
12th?
a no. Okay, you know what, Mr. Middleton, I got a fake letter that my funding was canceled after 4 months, but I know my Sandy, she came into the house visit, and I have 18 months funding, so
Well, you
I
may
wonder
have
if
got
Keystone
18 months
was-
funding, but there may
Yeah,
have to be
yeah,
something other than this.
Did you hear what I
All right,
said?
now,
Okay.
we're gonna continue this.
Yes,
I
sir.
told you what your rights were.
Yes,
We're
sir.
continuing it until next week. Now, let's repeat, you had a month-to-month lease in February.
Okay.
So she gave you a notice on May 7th telling you had to move. You
And that was
didn't
not
move.
filed.
It was
So
filed.
June,
So
and you
on
said
June,
June
she has
7th.
to wait for 30 days to pass. So you
June?
didn't move. And on June 7th, she filed this termination of tenancy action.
Does the notice
Then
to
we have
quit
to
have to be
schedule it
filed?
for a hearing. Then we have the first hearing, and then it gets adjourned for 7 days.
Sir. Yes,
But
sir.
if
You're going
she
to attack
gets
me on
what she
every
asked
level
for,
possible, all at
Jamal,
once.
you always interrupt me, and
Yes,
no
I
matter
do.
what kind of
Yes, I
case we're
do.
doing. I will give you a chance to speak. Let me finish. If she gets what she
Bit much all
asked
at once.
for, you would have until August 22nd to move out, or you would be subject to being evicted. If you
Okay.
have some defense or other issues that you wish to raise, you can do that next Friday
Okay.
at 10:15
Can I say
in the
who
morning.
is Jamal Black?
Oh, here we go. Release the sovereign citizens. If they can find their own way out, of course.
Can I say that? Who's Jamal Black? Because I don't know who that is. That's not me. So I shouldn't even be at this court proceeding because I don't know who the person that is filed to be the court is. And should I
Well,
take
it's
that
spelled
stipulation? Yes, it's who is that man? It's not me.
JAMALL.
A-L. Who's that? No, no, it says
All
J-A-M-A.
right, well, that's you. So
It's
be
me?
here next
That's
Friday.
not me. My name is J-A-M-A-A-L-L.
Well, we'll
So
fix.
you're gonna edit something else? Huh.
Yeah.
I'm gonna play
All
hardball
right.
now.
I bet they're scared. You're going to play hardball. But let me ask you this one, Jamal. You claim that the guy on the thing is, and I quote, snot you. So if that's the case, why are you in that guy's house then? Because if it's snot you who's supposed to be in court, then it's also snot you who's supposed to be in that guy's house. Ergo, you are trespassing. Bet you didn't think of that, did you, Savvy?
Yes, sir.
Yes, okay, I'll
On
see you next Friday. Gene, I don't know if you have anything to add. We don't smoke in court. But come back next Friday at 10:15. Miss Foster wants him to go And I don't know what else to say about it. But we'll
I
be
do
here
have a
next-
question, sir.
Yes, certainly.
So at this point, Jamal has not been evicted. Is that
Correct.
correct? So
Correct.
he should have a key and free access to his room.
He should.
Is that the case? It is
I don't
not
know, man.
my understanding as of a couple of days ago. Actually, as of yesterday. It's not my
What can
understanding.
tell us about that, Ms. Foster?
He's in his room right now. Yes. I
Does
don't
he have a
know
key?
about- If he does not have a key, it's because he's lost it.
All right,
I
we'll be
haven't been-
back next Friday to deal with this.
And the lots are not changed.
She's not his lawyer.
All right, so it seems like his mom came in there to try save his skin at the end. I bet that's also not going to work. Here's the thing. If you're a Sovsid or not, it makes no difference. If you're using somebody else's property, be that a vehicle, be it a room in a house, be it a house, bloody pay the people for it. First of all, don't expect all the rest of us to pay it for you. Unless you're in genuine trouble, and then most of us are good to do that. Second of all, don't try weasel out of it by saying, well, you misspelled my name, so I don't have to pay for like a year's rent. But anyway, I did a little bit of digging to see if I could find out some more background. He did make a short video actually after this, explaining that the judge wasn't allowed to edit anything or whatever. It's pretty much unwatchable. But there was also some Facebook posts that I found very, very concerning. The first one, not so much. It says, the country makes money off our court date being broadcast live on YouTube. No, it doesn't. None of those videos, from my understanding, are monetized. So no, they don't. This is about providing it to the public the same as you would be able to walk into the back of a court and watch proceedings. And then there was the next one. It says, I'm done. I'm going public. I'm going underground. I'm going political. Fine. I can't read it out, so read the screen. The whole MF'er down, and then a link to the Department of Justice. So obviously that's quite concerning, and it has been reported. So anyway, folks, that's all we got time for. Just remember, if you struggle to pay your rent, all you have to do is claim sovereign immunity as a sovereign citizen, and oh wait, no, that's not going to work at all. So Jamal, let me say this to you. Get out of the other Jamal's house, because that guy owes a lot of rent, and he's going to get evicted. Obviously, I know that guy is you. You know that. Everybody knows that. But you, with your big smug head, really seem to think you're going to get away with it. Now, you might have seen a lady on the bottom of the screen earlier on in the video. There's a video up about her as well. Unbelievable. She claims everybody's racist, yada, yada, yada. Go check it out. It'll be linked in the description down below. We'll catch you in the next one, folks. Sláinte. Ever get in trouble with the law? Just claim you're not a citizen of that country and inform the judge that they don't have jurisdiction over you. Because reasons and such. Right now we got this amazing video. It's a Moorish sovereign citizen who goes ahead and fires his lawyer. Let's get straight into it.
Hi, may I say something to my attorney first?
Not privately.
Yeah, I know it's not going to be privately. Can you hear me, Miss Reed?
Yes, I can.
You asked me if I was a U.S. citizen properly before. I was confused by the question. I didn't understand it. I'm not a U.S. citizen now. I'm a Moorish American national. I just want that to be on the record.
Okay. All right, what's your name, please?
Hi, my name is Eddie J. Carter Green Jr.
Is this all him? Okay, Mr. Collier Green, I have 1, 2, 3, 4 felony files here. I don't believe you've been arraigned on any of them. So I'm going to start with your contact information. Oh, there's also a PPO.
Well, there wasn't.
Violation.
No one got it, the one for the last.
Now they're sending me every possible PPO violation, so there's also that. So 5 things altogether. So let's start with your contact information. Are we using the Jane Street address in Syracuse, New York?
Yes, ma'am. I haven't lived in Michigan since 2018.
Okay. So you just were here long enough to be charged with 4 felonies?
No, ma'am. I never came to Michigan,
You
ma'am.
are charged with 4 felonies that
Yes, ma'am, I
all
was.
took place in Washtenaw County.
Yes, ma'am. I never came to Michigan. I was in Onondaga County the entire time. I never came to Michigan.
Okay.
Paperwork said I was a fugitive.
Your Honor, the people are asking for a $50,000 surety bond in each of these criminal cases. This is a series of escalating aggravated stalking charges involving threats to kill his estranged wife, kill her family, burn down her mother's house. He has said that he's hired a private investigator and given specific details about the victim's habits, including what door she's going in and out of at work. Contacted by law enforcement, he told them that they couldn't do anything because he's out of state. None of the orders, PPOs, instructions from law enforcement have done anything to stop this behavior and these escalating threats. He's absolutely a flight risk. It's believed that the only connection he has to Michigan at that time is the victim who's here. He had to be extradited from Syracuse, New York, including going through the governor's warrant process. After he was arrested, hiding in a closet, and refused to acknowledge who he was. He's a danger to the victim. He's a danger to society, and he is a flight risk.
Despite the fact you have not been served with this PPO, that these charges should proceed. And the conversation that we had is that there's some legal things that aren't particularly relevant to today about the difference between notice and service. But more importantly, there is a document out of the state of New York that has been served on you, according to the paperwork that I have, that prevents you from having contact with Miss Collier Green. So it is appropriate to proceed on these matters for today. Yes, sir.
Ma'am, I was served once I was taken into custody on May 19th. They served me once I went into custody.
Okay.
Form things happen.
Okay. The document that I'm talking about in the New York protection order is we were served last year in 2021, according to the paperwork that I have.
And it expires this year of May 20th or 22nd, I believe.
Okay, so I don't have that in front of me.
The information I got from Judge Vandenberg, this expires in May of 2025.
Right. Okay, so we're gonna go ahead and proceed. I just wanted to make sure that we all agreed on whether we should proceed or not. I'm satisfied that it's appropriate to proceed on these matters. So I've heard bond argument from both Mr. Doby and Ms. Reed. Is there anything else either of you would like to say regarding bond before I set a bond in the felony matters?
No, thank you, Your Honor.
Okay. Mr. Collier Green, one of the things that I am in receipt of is messages between you and the protected person, Janae Collier Green, and they are threatening. So I think that the reason that we have stalking as a criminal charge is because people should be able to live in a way that is where they feel safe and secure, and in order for a person to be charged with stalking, there has to be more than one event, and it has to be the nature of the events have to be of a type that would cause a reasonable person to feel terrorized or threatened or harassed or frightened. And that's using the word terrorized shows you how seriously the law takes the idea of people's peace and quiet and the right to be free from harassment. So what you are accused of is a ongoing harassment of a terrifying nature of someone else when there were court orders telling you not to do that. I think that a bond keeping you in custody is appropriate. Since you were arrested on May 19th, there have not been any ongoing contacts. So if that's what it takes is for you to be in jail to not engage in this behavior, then I think that a bond is appropriate. So I'm setting the bond at, I'm going to go ahead and set it at 50,000 as the prosecutor has requested on each file. You're going to be in front of Judge Simpson next Thursday.
I would like to say
Matter.
something.
Pardon me?
I would like to say something, Your Honor.
Oh, I bet this will be good. Let's hear it, buddy. Let's hear it. Because I think the only thing you're going to achieve is giving us a whole load of entertainment.
Go ahead.
I would like to relieve Attorney Sylvia Reed of her obligation and contract of me.
We're not doing that today. I don't have the authority to do that.
Well, I have one more thing to say, if that's okay. I, Eddie J. Collier Green, I present myself to this court in personam, and I would like to call on the bonds of all opposing counsel and plaintiff pursuant to Michigan compiled law, complete through PA 76 of 2022, Act 19 of 1934, Law 129-51, Bonds of Public Officials, Section 1, and Law 15-181, Section 1, Law Filing of Oath and Bonds, and Law 15-91, Official Bond Certificate. Pursuant to your obligations, ma'am, under Michigan Court Rules of 1985, Chapter 2, Civil Procedure, Rule 2-109, Security for Costs, and also pursuant to the Michigan compiled laws, complete through 76 of 2022, Filing of Oath and Bonds, Act 164 of 1848, 15-91. Can you please forward the copies of all bonds used to underwrite your interest and case numbers?
Nope.
Is this not a commercial claim, Mel?
No, this is not a commercial claim.
Oh, that was sweet. Hope you didn't waste too much breath on that big long essay that you read out to us. I didn't even look up what any of that meant because I didn't need to. Because the judge chopped you down so hard. It was like blah, 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 blah. Nope.
Well, the governor's warrant was printed on commercial paper from a commercial bonds company.
Okay. You know what? I don't want to do this with you because it's not necessary or pleasant or appropriate. All right.
Okay.
So I understand that your position is that my authority to set a bond for you is questionable. That's not true. I'm not going to explain why it's not true. I have many other people that I need to see today.
Okay, thank you.
Okay, but I hear what you're saying. You've made the record. It's on the record. Okay.
Yes, I would just like the bonds as a matter of discovery. I would like the bonds of all plaintiffs as a matter of discovery put on the record.
You can't ask me for discovery and I'm not a plaintiff. Okay. Now, regarding whether or not Ms. Reed continues to represent you, my authority to appoint and to approve the replacement of counsel is extremely limited. All I can do is appoint a person from the public defender's office.
I would like to go pro se. You're fired, Sylvia Reed, pursuant to the corpus juris sanctum.
I think he's talking about the corpus juris secundum, not sanctum. And that's a law encyclopedia, by the way.
The first obligation of an attorney is to the court. The second obligation is to the public, and the third is to the client. When you break down client is.
That's true. She argued appropriately for you to be released, and I'm not doing that, not because of something that she didn't do, but because I don't think that that's what is appropriate in your cases. So what I was going to say is When you are in front of Judge Simpson next week, at that time, you can again bring up that you would like to be to have either a different lawyer or represent yourself, and Judge Simpson can handle that for you. Okay.
Thank you very much.
My obligation is to appoint at these hearings, and then it gets cleaned up later on if it needs to be. Okay.
All
Can I
right.
finish your bond, or is there something else you'd like to say to me?
No, ma'am.
All right. So on all 4 cases, the bond is $50,000 cash or surety. On all 4 cases, the court date is September 1st, 2022 at 9 a.m. That's a week from tomorrow, next Thursday. On each of those 4 cases, you are not to have any, the bond, this is the bond that applies to all 4 of these cases. I'm not going to repeat it 4 times. I don't think that's necessary, okay? It's the same bond conditions for all of them. No contact with Janae Collier Green. No contact includes using someone else to contact her. It includes using social media to contact her. It includes replying if she contacts you, and it includes the direct contact of her in any form, electronic, over the telephone, in writing, sending something to her through the mail. No contact literally means no contact. Specifically, do not go to her address on Gulfside Road. And for each of these cases, you are not to use illegal drugs or purchase or possess a firearm. You are not to leave the state of Michigan without permission of the court. Do not engage in any criminal behavior or any assaultive behavior. Do you have any questions about the bond conditions for these cases?
No, ma'am. And you're saying for all 4 is 50,000 in totality?
Each file has 50,000, so a total of 200,000.
All right. Even though I've been in custody for 98 days?
Yes.
You think 98 days in custody is worth what, like approximately, I'm not great with numbers now, $3.5 billion trillion maybe that she put your bond at? Ooh, I can't wait for your next hearing.
As of right now, I've appointed the public defender's office to represent you on that matter as well. So you'll have someone available to help you. It won't be Miss Reed.
I'll prefer to go pro se. I don't need an officer of the court now.
I'm the kind of guy that likes to say, don't worry, buddy, you got this. You don't got this. You do not got this. Of all of the things in the world that you got, this is not among them. In fact, you don't got this so much that you ungot stuff that you already got. You don't got this.
I've been going pro se this entire time in New York. From all of my cases, I've been pro se the entire time. And do I need to get something submitted to the county clerk to relieve the council from?
You have to talk to Judge Simpson about it next week when you see it. Okay. So I won't appoint on the personal protection order. Judge Vandenberg may still decide that she wants you to have a lawyer, and that may delay that proceeding, just so you know. Okay. I don't know whether she will or not. I'm just letting you know that that's a possible outcome of choosing to represent yourself in that matter. So on that file, no contact with Miss Collier Green. Okay. Anything else on these matters? Okay. You're all set, Mr. Collier Green. If you stand up, then the corrections officers will know we're finished.
All right.
Thank you.
Well, that was a whole bunch of fun. I can't wait for the next 2. There's Judge Vandenberg tomorrow and then Judge Simpson this day next week. That's going to be juicy. You're not going to want to miss that one. Anyway, folks, I hope you enjoyed this quick clip. If you did, make sure and hit that like button, comment, subscribe, and all that stuff. Or smashing that thanks button down below. We'll catch you in the next one, folks.